Hi, I'm Shannon Gunn Emery, one of the lawyers with Gunn Law Group in Edmonton and in Hinton. I thought I would do a video on some of the most common questions that we get in Alberta about impaired driving related cases. So if you weren't aware, we have a rather odd regime in Alberta. Normally, at least during most of my career, that would be from 2001 when I started articling to 2020, I would routinely tell people, the criminal code is consistent across the country. So whether you were charged in BC or you were charged in Newfoundland, the rules are pretty much the same, right? And that is still true today. What really has changed is enforcement of the criminal code. Way back when, BC decided to opt out of enforcing the provisions of the criminal code with respect to impaired driving and decided instead to treat those cases as administrative in nature. And this is part of a larger trend of governments realizing that the criminal justice system is not always the ideal one for dealing with every kind of problematic situation that the government wants to handle. And there are some articles you can find online if you're more interested about this trend concerning opting out, as I'm going to call it, of enforcing the provisions of the criminal code. You see it with respect to assaults and definitely with respect to impaired driving. So Alberta, after hearing from the Supreme Court of Canada that BC's regime was pretty much okay, they decided to create their own, and it is called the Safe Roads Alberta system. Safe roads with a capital S and roads with a capital R, all smushed together because it's cute. Anyway, so if you are stopped by a police officer and they think that you were driving while under the influence of alcohol or drugs, then it is likely that you are going to end up with a notice of administrative penalty, also known as a NAP, also known as an immediate roadside sanction, also known as an IRS. They should have just decided on one thing and just called it that. But anyway, the notice of administrative penalty tells you about the sanction you're getting, which is an immediate roadside sanction. Now, we've had a few videos already about what to do about the process when you get the notice of administrative penalty. So things like you have 7 days to appeal, you have a half-hour hearing in front of one of the Safe Roads adjudicators, etc. But our clients routinely have questions about the stop itself and a few other related questions that we're going to answer here. So first of all, one of the most basic questions is, was I charged with something? And when we get a call from people, they will often say, I was charged with impaired driving. But were you really? And I know you're like, well, was I? Right. So the police can charge you criminally with an impaired driving related offense and give you a notice of administrative penalty all at the same time. But if there was no accident and if you have never been accused of anything impaired driving related before, normally they will only give you the notice of administrative penalty, which means you are not charged with a criminal code offense. And if you're not really sure whether you were charged or not, look at your paperwork. Is there anything that says promise to appear, appearance notice, undertaking, recognizance, or anything with a court date on it? If there is, it is likely that you were charged with something. If there isn't, and you just got a notice of administrative penalty, maybe a roadside appeal notice, a seizure notice for sure, that means you're probably not charged with a criminal offense. But whether you were charged criminally or not, the notice of administrative penalty on its own is not nothing. On a first occurrence, you're looking at a $1,200 fine and a 15-month license suspension. And you may say, well, that's not what I see. Well, yeah, I know. It can be confusing when you read that notice, but it is a 3-month absolute license suspension where you can't drive at all. And then if you sign up for ignition interlock, you can use that for the other 12 months. If this was a second occurrence, you're looking at a $2,400 fine and a 39-month suspension. First 3 months are absolute, and you can use ignition interlock for the last 3 years. And you may think, oof, that's really harsh. Wait. If this is a third occurrence or more, it's a 3-month license suspension where you can't drive at all, and then welcome to ignition interlock for the rest of your life. It is an indefinite license suspension, so you are stuck with ignition interlock forever. And just to keep the record straight, there is no indefinite license suspension under the provisions of the criminal code. So it may not be a criminal offense, but it's not nothing either. That notice of administrative penalty is something you have to take seriously. Okay, so now we've got a little bit of clarity over charging versus not charging, but so many other questions come up, like, I feel I was stopped for no reason. You might have been. It could have been that you had an officer who was bored and just decided to pull you over. As long as they say the magic words, I stopped the person for a vehicle document check or a driver sobriety check, they can literally pull over anybody. So the fact that they stopped you for what seems to be practically no reason, as long as they say the magic words, it's probably okay. I told them I wasn't driving, and they didn't care. They made me blow anyway. This is one we get a lot, and it has a lot of facets to it. So there are 2 scenarios where you were not driving and they could still ask you to provide a sample of breath. And this sounds super confusing to people and maybe shocking to some, but it's true. So number 1 is a care or control situation. Care or control means you were in the vehicle with the means, usually, of setting it in motion, but it wasn't actually moving. So sometimes people sleep in their vehicles. Sometimes people are sitting in their vehicle listening to music, having a smoke, whatever it is, but the vehicle wasn't moving, and all of a sudden you've got knock, knock, knock at your window. You have to provide a sample of breath, and you're like, but I wasn't driving. That's called care control, and they can ask you to provide a sample of breath. So refusing on the basis that I wasn't driving is the worst thing you could do. If by some great luck a client is able to contact us when they're in the middle of this situation where they're like, I wasn't driving, I shouldn't have to blow, our advice to you is likely going to be beg to blow, because if you blow over the legal limit, you have a defense in that you weren't driving. Yes, that is a defense, but it's not a defense to a refusal. The fact that you weren't driving may go to unfairness, but it's a lot harder to argue, whereas if it's over 80, the fact that you weren't driving, complete defense. Number 2, you had no reasonable expectation that breath samples were going to be required. So this part of the exception that you have to prove, and there is another one, 3, there are 3 parts you have to prove, but the second one basically goes to the scenario where you left a restaurant and the server said, Don't you dare drive. You're not okay to drive. I think you're drunk, and I'm calling the police. Da 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 da. You should have had a reasonable expectation that breath samples were going to be required when you got home because they threatened to call the police before you left. Or you were in an accident and you were able to drive away, but a civilian who stopped said, don't drive, I think you're drunk and I'm going to call police. Anytime you thought police were going to be called, that's where you're probably going to have a hiccup on that second part of the 3-part test. And the third part is very difficult, especially under the Safe Roads regime. Under the criminal code, it is that you have to prove that you had a blood alcohol level that was consistent with readings at the station and consistent with a blood alcohol level under the legal limit when you actually were driving. I'm going to give you a moment to let that sink in and think about how you are actually going to prove that. Not the easiest. Under the Safe Roads regime, you got home, you've been home for an hour and a half, you were drinking when you got home, and all of a sudden, knock, 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 at your door, the police are there, and they're like, we want you to blow. And you're like, pardon me? Like, why would I provide a sample when I haven't been driving for an hour and a half and I've been drinking since I got home? No. The other situation where you were not driving, but they could still ask you to blow, is even harder for people to understand. But don't refuse. It is so hard to beat a refusal. What we can argue is that there is an exception under the provisions of the criminal code, and it is worded almost exactly the same, not quite exactly the same, but close, under the Safe Roads Alberta regulation. And the exception that you have to prove goes like this. First, you were consuming alcohol after ceasing to drive. It basically says you have to show a blood alcohol level that was consistent with everything else, but that was under the legal limit when you were driving. So they're a little more amorphous about consistent with what, because another very confusing situation that comes up for people is, I wasn't taken to the police station, so what did I blow? Those are 2 more questions. I wasn't taken to the police station. I was just released at the roadside. Yep, that's what happens here. Everything rises and falls on that little handheld device. And I'm recording from our Hinton studio, so I don't have that little device here, but you may have seen I got one for my birthday from the people at my office who love me and knew what would make me really happy for my birthday. Yes, having my own Alka-Sensor FST. It's beautiful. Anyway, yeah, everything rises and falls on this little handheld device. And so another question that people often ask is, well, they said I failed. What does that mean? I never saw a number. I never got a number. How much did I fail by? Well, again, join the club. If the screening device, the Alka-Sensor FST, registers a fail, that means that your blood alcohol level was at or exceeding 100 milligrams of alcohol in 100 milliliters of blood. To put this into context that people might understand, the legal limit in Canada is at or over 80 milligrams of alcohol in 100 milliliters of blood. Often we truncate that milligrams of alcohol in 100 milliliters of blood to mean milligrams percent. So 80 milligrams percent is the legal limit. The screening device is set to fail at 100 milligrams percent, which means that you were over the legal limit. Now, there could be reasons why the screening device registered a fail, but you weren't actually over the legal limit, but that is a conversation for another day. Getting back to, I didn't get a number. I don't know how much I failed by. Well, maybe you did get a number, but if you did get a number, you're probably not listening to this video or watching this video, because getting a number means it was under 49 milligrams percent. So between 50 and 99, you would get a warn, and you're going to get a 3-day license suspension for anything in the warn situation. And that goes by so quickly that really the only reason why people would fight that is if it's going to affect your driving abstract, and that means something really negative for you. If you got a number, that usually means that you were in the area of a permissible blood alcohol content. Like if you got 30 milligrams percent, nothing should really happen to you. You might get a warn, you might get a 24-hour suspension because they're concerned about blood alcohol, but really nothing big should happen to you. Now, if they took you to the police station, you would be tested on the Intoxi CIR2 that looks like a laptop and actually gives a reading, regardless of how low or high it is, and we would know you were at 110, or you were at 210, or you were at 50. Whatever it is, it would give an actual number. It does truncate the last digit, so the last digit in Alberta, because of software issues, always shows a 0, but it would give a number. So since you weren't taken to the police station, we don't get that very specific number anymore. Another question that comes up, I asked for a lawyer and they just ignored me. I have no kind words for the constitutional conundrum that we find ourselves in Alberta right now. Right to counsel in this regime is unclear, and it's bizarre. So Section 10A of the Canadian Charter of Rights and Freedoms, that applies everywhere to everyone, says that upon arrest or detention, you have the right to be informed of your right to counsel. But that doesn't seem to be the case when it involves safe roads. I wish I had a better explanation, but the courts have struggled, and not well, with this issue. And so they're basically saying, as long as it is an administrative stop, which I will tell you can morph into a criminal stop just like that, but as long as it stays administrative, your right to counsel is more or less suspended. Now, they're really strong on the part about if the officer makes a screening device demand of any kind, and there are 2 types that they can make: an MAS demand, mandatory alcohol screening demand, or an approved screening device demand, which is also called an ASD demand. And if you're getting confused, you're not alone. Officers are also sometimes confused about this. But anyway, if they make any kind of demand where they ask you to blow into that little handheld device, your right to counsel is suspended. That part is very clear, and that part has long roots in our justice system. Way back when, in 1980s, Supreme Court of Canada said in a case called Thompson that right to counsel, that's your Section 10B right. Everyone has the right to retain and instruct counsel without delay upon arrest or detention. That right is suspended once the officer is embarking on screening for impairment. But that was a very different social situation. I do still feel, and the courts have not yet agreed with me completely, although some in Ontario did, that if you have a cell phone, which is basically a mini computer where you could look up any lawyer of your choosing, that you should be able to contact a lawyer. But in any event, I'm just going to truncate this to say it drives me crazy, and it probably drove you crazy too, and I think eventually this is going to change. But for now, in Alberta, right to counsel in the Safe Roads regime is unclear, and you are likely to come up against officers who say you don't have any rights. They literally tell people you have no rights right now. Anyway, so sorry that happened to you. Hopefully in the next 5 to 6 years, we are going to get clarity from higher courts, really high courts like the Supreme Court of Canada, where they reaffirm how important right to counsel is, because in my opinion, this is bringing the administration of justice into disrepute. Either the Charter is the supreme law of Canada or it isn't. Sorry, I can feel myself going on to a rant, and I know you aren't here to hear that, but you probably ranted in your own head about why you weren't given your Miranda rights. In Canada, they're called your Section 7 rights. I want everyone to chant, I want my Section 7 rights. I want them. Yeah, it's a bad situation right now. Another really confusing situation is, well, they said I could blow again, and they were talking about it being optional, and I wanted to get advice about that, but I didn't know what to do, and I didn't understand. What are they talking about that I could blow again? Yep, this is very bizarre, and it gets worse when police officers aren't clear about this regime either. And I have sympathy for some officers. I don't think they're always getting the best training. But once you've failed the roadside test, then they're supposed to tell you that you have the option, it's completely up to you, to try again on another device. And unfortunately, sometimes they don't describe this process well. And I will give kudos to our Court of Appeal in Alberta. They gave really clear direction to police as to what they should do to ensure that people understand what that second test is about. Even the wording second test is problematic, because for some people, where the officer went, as I'm going to call it, straight impaired, which I will explain in a minute, this isn't the second test, this is the first test. Poor you. If you're confused, let's break it down. So, first scenario, the officer asks you to blow, you blow a fail, and then this second test comes up. What the police are supposed to do is they are supposed to give you the notice of administrative penalty that spells out what the penalties are that you are now facing as a result of that fail result. Then they are supposed to give you the roadside appeal form, also known as the tearaway sheet. I don't know why. And it explains that you have the option of providing a second test. The penalties will not get worse. You get the benefit that's supposed to be explained, but it's not really explained on the form. But I'm telling you, the second test is supposed to allow you to gain the benefit of any lower reading. If you get a lower reading, the NAP would be cancelled. If you get the same result, then the NAP stays the same. So do you want to provide a second test? And what police don't always explain to people, some do, some don't, is basically there is no downside to providing the second test. Your situation is not going to get worse, it can only get better. So why wouldn't everyone provide the second test? And my feeling as defense counsel is if someone didn't provide the second test, it's because they didn't understand what was being requested, because if you knew there was no downside to providing it, why wouldn't you provide it? The Court of Appeal in Alberta has said that there has to be clear awareness of the right, and they call it a right, it's a procedural fairness right to the second test. They also have spelled out that that awareness really has to come from two sources, both the written notice, the notice of administrative penalty, and the roadside appeal, and explanation of what that means by a police officer. So thank you, Court of Appeal, for the Lawson and the two Lawrence decisions. They have been very helpful, but we still get police who don't clearly follow those very specific steps outlined by the Court of Appeal. The other scenario is even more confusing. So a police officer can, just by looking at you, following you, seeing the driving pattern, smelling the odor of liquor, noticing slurred speech, may just say, I don't need to do the screening device test. I think you're impaired. Here's your notice of administrative penalty. And then they have to ask, do you want to do a roadside appeal? That means that you blow into a screening device, and if it shows a permissible blood alcohol content, then the NAP would be cancelled. But imagine that you're in that position. The officer hasn't even asked you to blow. They've given you this penalty, and now they're asking, do you want to blow? It's awkward, and don't forget, you can't ask a lawyer first, what should I do? Super confusing. And that's why courts have said calling it a second test can be very confusing for people if there was no first test. In fact, the roadside appeal used to talk about second test. It referred to a second test. Well, what happens if you never had a first one? As I'm going through this video, I'm like, yeah, it's super confusing. And you're not alone. These are the questions that I get routinely all the time as defense counsel, which is why I thought I should put this out for everyone, because you should know too. You're not alone. If you are really confused by this situation, Safe Roads regime, which ironically the government said was brought in to simplify things, to make it user-friendly for people so that they wouldn't have to hire a lawyer. Oh boy. If you're trying to defend yourself, it is not easy. The courts have already talked about the fact that there are 4 pieces of legislation that you really have to know to defend yourself well in this situation. And they all fit uncomfortably with each other. The Provincial Administrative Penalties Act, the Provincial Administrative Penalties Regulation, which are 2 separate things, and one adjudicator I knew didn't know that, the Traffic Safety Act, and of course, the Safe Roads Alberta Regulation, which all of those, by the way, are only published in English, even though we have 2 official languages in this country. That's a rant for another day. Another question? Roadside appeal of the NAP. What exactly are we talking about? This is very confusing for people. There's the immediate appeal at the roadside, but you don't have that appeal if you were charged with refusal or failure to blow, which is stupid with respect to failing to blow, because of course the problem could be the screening device. So why wouldn't they give you an opportunity to try on a different device? But no, you don't get to try on a different device. You don't get the opportunity to prove that it wasn't you that was the problem, it was the screening device. Another rant for another day. But a roadside appeal, when we're talking about roadside appeal, we're talking about the second test, or the extra optional test, I will call it, at the roadside. But then you have the right to challenge or appeal your notice of administrative penalty by appealing through the Safe Roads portal, and you only have 7 days to do that. So that is what we would call the immediate roadside sanction appeal versus a roadside appeal. You following me so far? Okay. If I fight this, could they charge me with something later? They could, but they rarely do. So theoretically, is it possible? Absolutely. In practice, I have not seen cases where the person is released at the roadside without the promise to appear, appearance notice, recognizance undertaking, or whatever it is that is compelling their presence in court and given the notice of administrative penalty. I don't see that if they didn't get that court document at the roadside that they're being given a summons or a document that requires their court appearance later. So if you were released at the roadside with a notice of administrative penalty and the seizure notice, but nothing else, you're probably fine. The one exception to that, I would say, would probably be if you were released after a bad accident and you got either no paperwork or you just got a notice, but you were taken to the police station and samples of blood were taken, you may not be out of the woods yet. The final question I'm going to talk about now, and it's pretty brief, is I've heard nobody wins this. I've heard that now there are no arguments that people can raise. Well, that's not true. It's different. And sometimes, actually, with this new regime, I can give a stronger opinion than I could with a criminal charge. And you may ask, why is that? Well, for example, if they used a screening device, but there is no evidence about the calibration or maintenance expiry dates for the screening device they used, that's almost like an automatic win. And I would never, in a criminal situation, tell someone they have something like an automatic win. I might say they have really good arguments, but don't forget, trials are fluid. When you go to court and you're in front of a judge and that judge may be cranky that day, or the Crown may have a surprise witness, or the witnesses that you were banking on say surprising things, a good case can turn out to go right down the toilet. And what you thought was looking like a really hard case, you end up with a win. So that was quite common in criminal trials. In this regime, it's usually a lot more cut and dry. And one more thing to keep in mind, the whole case against you normally is on paper. And in the hearing, there is no Crown prosecutor arguing against you. Sometimes it may seem like the Safe Roads adjudicator is against you, but technically speaking, no one is against you. The whole case went in through the notes, reports, or other documents uploaded by police enforcement or, sheriffs. So is it harder to win now? No, it's just different. And if you want more information about what defending these looks like, listen to our podcasts, or better yet, call us at 780-488-4460, because if this video didn't cover most of your questions, we can. Plus, if you were actually given the notice of administrative penalty, you want to do something about it. Oh, one more issue. If you are late, if you didn't appeal within the 7 days, don't just go, oh, well, I guess I'm out of time, and leave it for 4 months and then realize, oh my heavens, this is really worse than I thought. I should see if I can appeal late. The legislation says you have up to 12 months to apply for a late review. But I have to tell you, even those who are 1 day late have been refused a late review. So don't sit on it. If you are out of time, do contact a lawyer, talk to them about it. If you can show exceptional circumstances why you weren't able to appeal in time, and there can be a whole big bunch of them, we should explore that. But the longer you wait, the harder it is to appeal late. So even if it's a week or two, call us. Once you get past a week or two, it's probably going to get harder, but still call us, because the preliminary advice when you first call us is going to be free. So no harm in calling us and just checking to see what are my options. 780-488-4460. I look forward to speaking with you. Take care.